In a class with a slightly different teaching schedule, I would typically do a wrap-up at the start of the next class of what we did in the prior class. With a 1 week gap between classes, that doesn't work so well. So I'm going to try it this way with this technology. What we did last night is a number of things. One of the things we looked at was the court system, and obviously the important difference between the fact that we've got both a federal system and then multiple state systems, that those run in parallel, and that one of the things that we have to do in the legal system is to figure out how to allocate cases between the federal courts and the state courts. We've obviously got a hierarchy in both cases, and so there's an appellate process where you move in the federal system from district courts to appellate courts to the Supreme Court. District courts, those cases are heard by one judge, appeals decisions typically by 3 judges, and Supreme Court 9 justices. Cases get into the federal system at the district court level through one of 2 typical paths in which the court can say, I have jurisdiction over this case, so the parties can bring the case to them and say, you have jurisdiction over it. One of those is federal question jurisdiction. It means there's a federal issue involved. Typical copyright case will be an example of that. Patent cases, bankruptcy, antitrust, you can go down the list. The second path, and the one we actually saw at work in AP versus INS, is the idea of diversity jurisdiction. And that's a situation where there's a sufficiently large amount of money involved that changes from time to time. And where the participants in the lawsuit are from different states. And that's what we saw in AP versus INS. I also mentioned a little bit in passing that there's a difference between jurisdiction and venue. That venue is among the federal courts at the district court level, which gets to hear it, even if we conclude that there is jurisdiction. In both the jurisdiction question and the venue question, there can be some interesting strategic choices that lawyers and their clients will want to make. From there, I turned to some hypotheticals on property creation and the social value of price discrimination, and then the question as to whether or not that discrimination is sustainable. That, in some sense, was the big theme of last night. Since in some situation, in one way, INS is taking steps to destroy the business model of the Associated Press, which depends in part upon the fact that it can charge on both the East Coast and the West Coast for the news that it creates. And then obviously in the Pro-CD case, Pro-CD is very much about discrimination, where Pro-CD has adopted a business model of selling both a professional version and a consumer version, very different prices. And as we talked about in class, highly unlikely that it would continue to sell both versions if Zeidenberg was able to do exactly what he tried to do there. On contracts, the heart of contract formation is offer and acceptance. And as we talk through the Zeidenberg case, I hope you got a sense of, as one of the students put it last night, is how indefinite these things can be. Right? There's really 2 strong different conceptions of what happens there. Zeidenberg wants to say that the contract is in some sense complete at the moment that he leaves the store, having paid cash and having walked out with the box of software. Pro-CD obviously wants to say that the point of real contract formation is at the point where Zeidenberg clicks through the contract. And we can maybe think that there's a first contract which involves the return rights, and then a second contract which is formed at the point that he clicks through. But in the first contract, Zeidenberg can only either accept the second contract or return the software. That's the nature of the deal as Pro-CD sees it. And the court, Judge Easterbrook, validates Pro-CD's vision, given what I think the court understands as the virtues of the price discrimination that Pro-CD is doing. One of the lessons from last night also is the range of tools that law has to deal with situations and the substitutability of those tools. So in AP versus INS, we've got a situation in which both copyright and unfair competition laws are on the table. That would in many ways be a copyright case today, but it would still have this unfair competition aspect to it, given the fact that even though news stories are now readily copyrightable, the ideas and facts in them are not copyrightable under U.S. law. And so even if news stories were brought into the copyright system, as they have been, but weren't at the time of AP versus INS, you still have this core question of what are the limits of the extent to which a competitor like INS can use the ideas and facts that it's able to extract from the Associated Press news stories. And the court clearly thinks that what the Associated Press is doing is valid and needs to be sustained, and then the question is what's the right legal framework for doing that, given that copyright won't work, and the court embraces this rather open-ended notion of unfair competition. We talked about some alternatives to that, and Justice Brandeis points to those alternatives in his dissenting opinion. Those alternatives are to effectively turn the Associated Press into a public utility. Ultimately, we take a couple of steps down that path in the 1940s antitrust litigation against the Associated Press, which forces it to move to much closer to an open membership model. The other alternative would be what Congress seemed to suggest, which is this statute, this 8-hour statute. And it's interesting to see that France and Germany are making noises about moving to something like that with regard to headlines, vis-a-vis Google and other search engines right now. The NBA and fly-on-the-wall cases, I think, are interesting because they show you the power of these older notions and how applicable they are today. So when Motorola wants to release sports tracks, you can see, and I thought our discussion brought out nicely, the questions Motorola is going to face with regard to its ability to use the information. Licensing the information is going to be expensive, it's going to slow down the process, and it's effectively going to impose a tax on that innovation, as we talked about in class last night. So that's clearly the downside of treating the NBA as having a property right in its scores. At the same time, it would be easy to sort of say, well, AP versus INS says that there's this hot news protection, and therefore the NBA is protected. And what we see in NBA versus Motorola, and again, the discussion last night brought out nicely, is that precisely because with regard to the distribution of this information on a sports track type service, on a pager type service, Motorola was making exactly the same investments in that the NBA would be doing. There was no free riding in that sense. Finally, then we talked briefly about the fly-on-the-wall case, and it shows you again how thin the lines are between, as it were, appropriation or misappropriation, free riding a la AP versus INS, and genuine news reporting and the like. And so if you're interested, I urge you to go at least flip through online the Second Circuit decision on AP versus on the fly-on-the-wall case. Well, that's what we did last night. Thanks.